Assalamualaikum warahmatullahi wabarakatuh. Welcome back to our Zoom recorded lecture. So the topic for today is privity of contract. This is the topic after the previous topic, which was promissory estoppel. So privity of contract is actually just a small topic, so not many things to be covered. So we don't have many slides actually. Not many lecture slides. So it's not that bulky. Let's have a look what I have here. So we want to know what's the definition of the word privity. So privity, it comes from the word privy. So what's the meaning of the word privy? So privy, it means whenever somebody, he is made a participant in knowledge of something private or secret. This is actually the general or the plain definition of the word privy. And another meaning of privy is secret or conceal. Okay, let's have a look. And when we talk about privity of contract, it relates to, under the scope of contract law, actually, it refers to the relation, okay, the relation which subsists, which exists between two contracting parties. So the focus is now actually on the relation between them. Okay, meaning here we have two parties, two contracting parties, two parties which who have entered into the contract. So what the doctrine is all about basically. So the definition was provided, okay, was made clear, okay, was interpreted. The term doctrine was elaborated in the case of Twaddle and Atkinson, and the judge was Whitman J. He said that no stranger to the consideration can take advantage of the contract, though made for his benefit. Meaning here there's certain limitation as far as the parties to a contract is concerned. Okay, and then we have another judge in the same case, Crompton J. He said that only a party who moved the consideration is entitled to sue. So from both of the definition or explanation here, we can see that actually this doctrine has some connection with consideration, with the rule governing consideration. The full name of the case actually is Twaddle and Atkinson, okay, executor of Guy the deceased, and it was reported in year 1861. So basically what we learn, okay, what we extract from this case, okay, basically from this case, it is to be noted that there is the principle, okay, that consideration must come from the promisee. So in other words, no stranger to the consideration can take advantage of a contract. Meaning that he's not involved in the contract, so he can't really take advantage of it. Okay, cannot really be involved later. All right, let's go to the facts of the case here. Twaddle and Atkinson. It involved three parties actually here. Okay, fathers of husband and wife. So the fathers here, they agreed in writing that both, okay, should pay money to the husband, and then adding that the husband should have the power to sue them for the respective sum. So that's basically the agreement between the fathers here, both of the fathers. And then later, husband wanted to claim, okay, the husband's claim against his wife father's estate. I mean, they have both fathers have passed away, okay. So now the husband was claiming against the father's estate, but it was dismissed. And then the court give justification that, okay, the decision was largely because no consideration moved from the husband, because the agreement, okay, when the fathers were alive, okay, actually it was made between them. Okay, husband was not a party to the agreement, even though it was made for the benefit of the husband here. And of course, because the husband was not a party, so there's no consideration from the husband to the fathers. So basically, Twaddle and Atkinson actually is the leading case, okay? The leading case in which the third party was denied such a right to enforce the contract. Meaning here, denial of right. He cannot really enforce the contract, even though it was made for his benefit. And then this case, that's why it is considered as a leading case, because the case has established the doctrine of privity in English law. So way back in year 1861, 19th century. And then, actually, if we relook at the judgment, okay, the remarks or the the rule, okay, which has been established in this case, actually, we can see that actually the two principles of privity and consideration, they are very, very closely connected, okay, or they become entwined. Okay? But again, they belong to the different topic altogether. Okay, entwined, okay, related, but then they are still distinct. They are still different. Okay, and if you refer to one of the textbook, we have many textbook, but one of the textbooks is written by J.H. The author is G.H. Trital. The title of the book is The Law of Contract. So he said that it is written in the book by the author. The doctrine of privity, it means a contract cannot, okay, as a general rule, both ways. It cannot confer rights, it cannot give right, or it cannot also impose obligations, okay, arising under it on any person except the parties to it. Even though it was made to, to benefit some other parties outside the contract, but later anything happen, the parties cannot take action, cannot enforce it, because only the contracting parties can sue each other if there is any problem later. So in other words, the rule is that only those who are parties to the contract, or only those who are privy to the contract, can sue or be sued, both ways, okay, can sue or be sued, and then no third party can sue in his or her personal capacity. Again, on the basis that because third party wasn't part of the they are not contracting party at the first place, okay, even though it might affect their their interest, okay, maybe it is made for the third party's interest, but then third party is not the parties to the contract. And what's the legal reasoning behind it? So this is common law reason, okay, is that only a promisee may enforce the promise. Okay, mean that here, if the third party is not a promisee, okay, is not promisee, not a promisor, so he's not privy to the contract. He's not part of the contract. He's not a party to the contract. And then again, we have decision by House of Lords in this case. Okay, another case which is 20th century case, 1915. The case name is Dunlop Pneumatic Tire Company and Selfridge and Company Limited, 1915. What happened was that the first agreement, okay, plaintiff, they sold tires to Dew and Company. So Dew and Company is the wholesale distributors, okay, and there's certain terms, okay, for the contract here. The term was that, okay, Dew, okay, the contracting party here, would obtain an undertaking from retailers. Mean that here, contract is between plaintiff, the one who sold the tire, okay, to Dew and Company. But undertaking, the promise is that, okay, Dew has to promise that must make sure that the retailers, okay, would not sell the tires below the plaintiff list price. So there are two different contracts here. First is between plaintiff and Dew and Company, and then Dew and Company and retailers. Okay, and then plaintiff didn't have any contract with the retailers because contract is only plaintiff and Dew and Company. And then what happened was that Dew, okay, the wholesale distributor here, they sold some of the tires to the defendants. Defendant is the retailer, okay, and then the retailer here, retail, sold them below the list price, whereas plaintiff said must sell at certain price, not below the list price here. Okay, so now plaintiff sought injunction and damages against the plaintiff, against the defendant. Defendant is the retailer. Remember, okay, there's no contract between plaintiff and defendant here. So the court held that, okay, the action failed. Okay, why? Because there was a contract. The court admitted that yes, there was a contract between defendants and Dew. Okay, and the contract is only between defendant and Dew. And plaintiff here, the plaintiff actually had contract with plaintiff and Dew, not the the plaintiff were not a party to it, okay, and only a party who is a party to contract cancel. Meaning here, because you are not a party to the contract, another contract here, because you have to contract here, all right, the second contract is not a party. So you cannot sue on it. Okay, it will be different if the vendor, okay, has contract with the retailer. Okay, now the contract is between distributor and the retailer. If anyone were to sue, then it was supposed to be distributor. Okay, not supposed to be the manufacturer, the one who manufacture the tire. Okay, that's basically what happened in Dunlop pneumatic tire and Selfridge. And then also it is stated in this case, okay, this is the judgment. Okay, our law, it refers to English law, okay, knows nothing of a jus quaesitum tatio arising by way of contract. Okay, what's the meaning of? Because this is one of the argument put forward by the council. So jus quaesitum tatio, it means that it is a law in Scotland, and if we look at what's the meaning of this Latin phrases here, it means right acquired by a third party in a contract between others. So, I mean here in under the law of Scotland, there could be some rights obtained by third party. Okay, but for English law, they didn't recognize, they didn't allow the rights to third parties. Okay, again, another question to be considered. Okay, what if the contract was made for the benefit of third party? Okay, for example, A promises to do something for B, okay, and in return, B promises to confer some benefits on C. So now the contract is between A and B, but it affects C as well. But C is not a party to the contract. And later, there's a breach of contract between A and B here. B did not perform his promise, so it affects the rights of C here, because C is supposed to get some benefits based on the contract between A and B. Can C actually sue the one who breached the contract here, B? So but if we were to apply under privity, the doctrine of privity here, C actually cannot sue on his, even though it affects interest of C here, because again we go back to who are the contracting parties here, is between A and B, even though it affects third party here. But again, the latest position in England, they have codified the law. It was made very clear. The law has been changed in England by a statute, specific statute. Was done, I mean, it was 1999 statute. Now under this specific statute here, which is named the English Contract Rights of Third Parties Act 1999, under this contract, a third party has now the right to sue. Specifically section 1, section 1, and then section 2, section 1, and section 3. I'm showing you the I think I opened it. How to share? Okay, let me try to share. Not sure whether I can share or not. Yeah, this is the one. This is you can Google actually. This law is available on the internet. So this is right of third parties 1999. Contract Rights of Third Parties Act 1999. This is UK law. We don't have equivalent in Malaysia. We are going to look at section 1, section 1. 1 here. All right. Subject to provision of this act, a person who is not a party to a contract, which is a third party, may in his own right enforce a term of the contract if the contract expressly provides that he may. And then subject to section 2 here, all right, the term purports to confer benefit on him. Meaning here third party actually can sue. And we go to section 2, section 1 here. Again, third party has provided, this is the requirement. Third party has communicated his assent to the term, to the promisal. And we also have section 3. Yeah, right. Proceeding for the enforcement of term are brought by a third party. So it's possible, to have a proceeding or action initiated by third party. Right, we stop here. We are going to continue in the next part of the lecture. Assalamualaikum warahmatullahi wabarakatuh.